Okay. So, good afternoon and welcome to Monos featuring me, Monica Mo Justice. Okay, I finally, I'm doing so much better, but we never know. I just did this whole test run earlier, so let me see. It's only gonna take a minute to see if this works. All right, it does. So hold up a second. Hey, Donna. All right, let me just fix one thing with this thing. So um we gonna try it over there. Hold on a second. Let's see if that works. I don't think so. All right, hold up. Let me bowl up. All right, hold on a second, cause I can't. All right, let me come over here. I'm getting so much better at this, but I'm just not there yet. Okay, so we're here. Oh man, hold up. All right, hold up. I'm still doing it. Hold up. Okay, so let's see where I'm at with this. No, it's here. And then now it's this one. Oh, SEMO. All right, so let's see. Well, let me see. Can I do it? All right. So 1 second. I don't know if this is. I don't know how this is gonna work. So let's try to see if it'll work there. Let's see if that works. Cause you can't be like everybody else. All right. Let me lock that. Let me go into Mono. All right, let's see if that. Let's see how that works. Let's see if I got this going on. Hey, Donna. All right, you go, girl. You doing something over here. You ain't doing much into something, but you doing something. You got something going on. All right. I don't know what that's about. All right, there's just one little thing I need to fix, but that's it. So, is it my mic sounds nice? I could turn it up a little bit. All right, let me check it out on this end. All right, let me check it out on this end. I'm not really sure. That's not really hitting for me, but let me try it that way. All right, 1 second. Let me see it this way. All right, it's not clipping. Is it clipping? No. All right, it will be all right. Let me see it this way. All right. All right. I just think the thing looks tiny. Hold up. Oh, me and this chat trying to get this chat together. All right, hold up. Hold up. I don't know why that looks so small to me. Does that not look small to y'all? It looks small to me. All right, y'all just don't be writing long chats because I think we're gonna have a problem. All right, we'll just roll with that. All right, let me go back. Now I gotta go back and try to find the darn chat. You know I'm doing all of this for chat love, right? Just to find the chat. All right, where's this? Where's this person? Okay, okay. We looking pretty. We looking pretty good. We looking pretty good. And last but not least, where's that other thing? Okay, so here we are. All right, what am I going to discuss today on a Sunday that's going to be different from what you guys have probably heard all weekend long since maybe Thursday when the case shut down. There was a lot of conversation back and forth and forth and back and forth about that this detective or investigator now, whatever you want to call her, is the final witness on the prosecutors. Um, and then the prosecution is going to rest their case. Now, for me, a person who was not. Thank you, Ariana. Oh, that sounds so cute. Oh, thank you very much. That sounds so nice. I've been trying. I couldn't get this to go. It just was. Okay, boom. All right. So, see, a lot of people use the other software programs, and I wanted to design something all of my own, like I used to do. Okay, my friends think that I have to decompress, all right, because this was stressful doing this little bit of a setup, but it's looking decent. Go ahead, girl. I ain't mad at you. All right. Anywho's, YSL cases, prosecution's case, the state case, it sounds like it's coming to a sizzle. Unfortunately, I was busy this week, so especially on Thursday, I didn't really get to do a check in. And to be quite honest, after my whole Thursday, Friday I was exhausted, and yesterday I was just recovering, and today I'm here for it. But what I wanted to discuss, and I'm not gonna be able to play any video for you because that's gonna be a whole nother thing I need to do. I just got one more piece with the Zoom that I gotta work out, and when I work out the piece with the Zoom, then we're gonna be on and thopping over in here because I'm gonna get the little well, the Zoom will pull me up to the top, and I'll get to share the screen the way I want to do it. So I just got one more phase to this that I haven't sorted out. Okay, so what I want to focus on is the charges against the defendants that remain on the case. And I really want to manage everybody's expectations. And I want to talk about the Blay. I want to talk about the go live, and then these people will start texting you, calling you, doing all kinds of things. All right. So I just want to circle back to that appeals hearing, and I'm just gonna say this. if I listen to, it's always good to do your own due diligence and then come up with your own, with stuff you're willing to live with. So here's a few things that bothered me. So I'm talking about Blalock. All right, first of all, the appeal was at the point that it was at. Oh, see how nice that is? Now people come in, they know what we're talking about. All right. Blaylock's appeal. Um, it was at the Supreme Court, or let me just make sure I get the language right. Now look, I gotta go all to, now I'm on my laptop. So I got desktop set up here, but I gotta go to my laptop. Okay, so this case was um appealed, so it was on appeal, and I think now I've read where the appeal was denied. Okay, so there were four issues in the appeal. Oh, let me move this chat over here. Today we're gonna be interactive, Mr. Chat, Mrs. Chat. So if you chat with me, we could do this because that's why I went and got the little chat feature and put the little chat feature up there so we could all be one. See where we at? Okay. So, all right. So I read. I was so confused when everybody was like, they were at the Supreme Court and it's about to hear the case and all this other stuff. So it went to the Supreme Court of Georgia. So now I'm looking at the blue black um, from, yeah, I said blue backs. I'm looking at the blue backs from the case. And in the case, and shout out to, I got all the documentation that I'm utilizing today. I was able to acquire it from Catnut Williams. She had the all of the documents in her live stream, in the description box. So I was able to pull the materials from there. So Brian still filed the appeal. The state responded as well. But guess who else responded? Do you know who else responded? Do you know who, what, who? Okay, wait a minute. So, um, so, do you know who wrote a brief? right, so let's just get these three entities. Um, the state. Okay, so put a poll inside the chat for y'all. Do you know who wrote a brief in the Blalock case? So anyway, going back to it, I started to because I was confused. I was confused as to why they was at the Supreme Court, but now I understand why they were at the Supreme Court. So let me just read to you um a statement of facts. And honestly, this is why I thought that some people are missing from this from this whole RICO. Um, I try to highlight all my good points. All right. Anyway, I'm not gonna read you from Brian Steele's, but I am gonna read you from um, the brief that was filed by the Attorney General. And I found this to be extremely interesting because since we've been watching this case, one of my first go tos was, why hasn't the Attorney General taken over? Because this is such a dip show, right? And I was wondering why there's been silence on that, on from that person, and only to find out that there really hasn't been silence. So let's hear what this brief has to say. The statements of facts. The evidence presented at trial showed that on February 23rd, 2019, appellant shot and killed victim Jamari Holmes with a firearm and committed aggravated assaults upon Rodney, and boy, do these people spell people's name wrong, Rodney Uten and Bernard Mitchell during the murder of Holmes. All right. At just after 4:30 a.m. on February 23rd, 2019, law enforcement received complaints or reports of shots fired in an apartment complex at 50 Mount Zion Road in Atlanta. Now I found out a lot of things as I was reading this thing that I did not know before. That we did not get from the testimony that was provided in the case. Um, from the testimony that was provided in the case, or what we heard in the YSL trial, a lot of this stuff didn't come out with the detective or Mariah Delaya. We didn't get this kind of detail. So here we go. Law enforcement arrived at the complex a few minutes after the shots were reported. When they arrived, a blue Dodge Charger was stopped on the small entrance road next to a grassy field facing the entrance. Okay. Victim Holmes was in the front passenger seat of the Charger, and it was quickly discovered that he had been shot, and the seat and floor of the car were covered in his blood. Now, I'm going to say this. We now know, or at least I now know, the vehicle was stolen. This blue Dodge Charger was a stolen vehicle that these three young men were in. It kind of shifted my opinion of Miss slightly about the chicken head girl that was there, Mariah the liar, because I can understand why she was scared. Every which way she turned that night, she was getting herself deeper, and she was in some deeper stuff than the previous moment before that. Anyway, victim Holmes was in the front passenger seat of the Charger, and it was quickly discovered that he was shot. Okay, so he was taken to the hospital, but died approximately 40 minutes after he arrived. Okay, so his friends who were shot at by somebody in this complex that they don't live in and wasn't familiar with, which incidentally is the same complex that um, Little Rod lives in. Okay, so um, the fact that his friends abandoned him, like if you wasn't doing anything wrong and you got shot at in a car that you shouldn't have even been in because you stole it. Like, I can understand people feeling like something else happened. Like, all of these stories have where you can have reasonable doubt without some concrete evidence, like a video or something, to really tell the other part of the story that you don't understand. But in any event, I would never leave my friend behind inside a vehicle to die. Period. Oh, see, that's gonna make me want to hold up a second. Hold up. All right, so I'm gonna have to hold up. I'm gonna have to do something. Oh, cause now you wrote me a long one, and I realized that it don't all fit. So hold up. You know where we're gonna have to put this? We're gonna have to put this all the way at the top somewhere. All right, so well, thank you for the long one. So now we're gonna leave that there. Hold up. This is helping me with my editing, but I think I'm gonna put it up. We're gonna leave it there. We're gonna go over here. We are going to. All right, tell me how that looks. You know what we're gonna do? We're gonna move it to the top. Okay, I think I can live with that. Okay, I think I can live with it sitting over there. Now I'm trying to get in the program, girl. Bye. Okay, so anyway, All right, here we go. So so what we discovered, I would never leave my friend behind, and they left him behind anyway. He was taken to the hospital, died approximately 40 minutes after they arrived. The medical examiner, the medical examiner, um, determined that Holmes was killed by a gunshot to the left somebody's scalp and the left side towards the back of his head. So all of these people just be getting shot towards the back of their heads. But anyway, um, but here's the important thing: he was shot with a 7.62 millimeter bullet fragment that was recovered from his body during autopsy, or actually from his head, because that's how they write it, from his head during autopsy. Upon examining the crime scene, law enforcement found law enforcement found oh, you know where I should put that at? All right, hold up. We're gonna have to go back. Hold up. You know where I need to put that at? Y'all know where I'm going with this, right? Do 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 do. Boom 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 boom. Oh, that's where it should go. Oh, wait a second. Let me just come over just a little bit. Just a little bit. I think that's going to be where it needs to be at. Okay. I think we found a solution. I think that's better. Okay, here we go. So, um, so they found 15 7.62 millimeter shell casings on the ground around the outside of the breezeway. So we know that the shooters, from the testimony that we did hear in the YSL case, that the shooter came out of the breezeway, or there was some activity going on in the breezeway, and that there were two types of shell casings that were found. But here's what's important: a ballistics expert who examined the casings determined that they all were fired from the same AK-47 style rifle. Now, after seeing the other guy put bullets inside this other gun that wasn't, we learned a lot about bullets in this case and modified weapons. Anyway, law enforcement also found four, uno, dos, tres, cuatro, only four 9 millimeter shell casings at the scene. Two were on the ground near the building closest to the charger. So, another thing that we discovered from me reading the report that came from the Attorney General is that when they arrived on the scene, I don't know why. How did you envision them? Me, I felt like they had just pulled up, and you know how a bunch of cars are parked, either facing the building or coming out of the building. I envisioned like they was parked and the person got out and ran, like they was parked as if they came into the building. So the passenger side was in front of all the cars. Come to find out that no, they backed up and they backed into a parking spot that was in front of the breezeway. So if you're just sitting there waiting, like they wasn't like in a drive off position where they just rolled up to the parking lot. They actually took a parking spot and backed into it, so they couldn't see anybody coming from behind them. That would make it an ambush. So that's what makes the ambush sound so great. um and two so all right, two of the shell casings were on the ground near the building closest to the charger. The other two 9 mm casings were on the charger. One was sitting between the car's roof and quarter panel, and the other was in the gap where the rear windows met the trunk. Okay, do it what you may. Do with it what you may. The ballistics expert determined that all four 9mm casings were fired from the same gun and opined that the gun was most likely a pistol. So we know they had a pistol and a rifle. The question is, were both of the guns that these casings came from were with Blalock and Ryan, um, or was one of the guns with Blalock and Ryan, and the other gun was with the two men in the car, one of the two men in the car. All right. There were a number of bullet defects in the Charger, and law enforcement found bullet fragments inside the car. Law enforcement reconstructed the path of one of the bullets that caused defects, determining that it entered the rear of the car, pierced the back seat, and exited through home seat. There was blood around the exit hole in the seat cushion, and the rear driver's side tire had been shot and was flat. So I was just a little bit confused because there was blood around the exit hole. So now we're supposed to believe that these bullets came in from the back and the left, and one of them went pierced the back seat and exited through home seat. So, but it ended on the rear driver's side tire had been shot and was flat. I don't even want to get through it. Anyway, Mariah, new appellant, and his co-defendant, Rodadius, they put your whole government up in here, and was able to identify both of them in the courtroom as the shooters. One of the problems with the case against these two men is that the key witness is a live person, and live witness testimony is not that credible, and she's only proved it with her testimony. All right, Smith explained that Ryan lived at 50 Mount Zion Road, but in a different complex, while appellant lived in another apartment complex not far from the crime scene. All right, so appellant is Blalock. All right, before the murder, Smith and so Mariah the liar and Hartfield, which is Breezy, were hanging out at Blalock's home with him and Ryan, right? Shortly after the shooting, Mitchell, Holmes, and Uten, all right. So these are occupants in the car, arrived in the Charger shortly before the shooting. Mitchell, Holmes, and Uten arrived in the Charger, and Smith went outside to meet them. Mitchell was driving the Charger. Holmes was in the passenger seat, and Uten was in the back seat. Smith got in the car, and she and the victims talked about getting marijuana. Then Hatfield came out of the building and got in the car. At that point, they drove to 50 Mount Zion with Hartfield directing them. When they arrived, Mitchell backed into a parking spot outside the building's breezeway. Hartfield got out while Smith and the victim stayed in the car. A few minutes later, Hartfield came back and told Smith to get out because Somebody needed to see her. Smith then got out the car and walked toward the building. Around the time she reached the breezeway stairs, the gunshots started. She saw appellant, so she saw Blalock and Ryan running and shooting at the Charger. When the police interviewed her the day of the shooting, she said Ryan had a big black gun and Blalock had a smaller gun. When law enforcement showed Smith a picture of a rifle that fired 7.62 rounds, she indicated that it looked like the kind of gun Ryan used in the shooting. At trial, Smith acknowledged lying to the police about the shooting initially, but she explained that she lied because she was scared of the appellant, which is Blalock, and Ryan, and maintained that she saw them shooting at the victims. All right. Another part of their inconsistent story, or at least her inconsistent story. Hold up, I probably messed this all up. I'm gonna hurt myself if I mess this all up. I think I messed it up. Ugh, this is so temperamental. All right. Okay, so Mitchell had a similar account of the events before the murder. She explained that after Smith got out of the car, this is the guy, this is the driver. He just heard shots from behind the Charger. Mitchell tried to drive off, but the car stopped before he could get himself, Holmes, and Mitchell out of the complex. He only saw one shooter, didn't see the face, nothing, but the shooter had dreads just past his shoulders and a hoodie on. So he described the shooter as having a hoodie and dreads, and that was interesting. So moving on, when interviewed after the murder, Mitchell described the shooter as tall with dreads with a hoodie. Uten, another of the victims, recalled that somebody started shooting after Smith and Hartfield left the car, and he did not see who was shooting. But bullets were coming from the car, were coming through the car. The bullets stopped as the car started driving away. In his statements to law enforcement, Uten said a tall man with dreads came out of the breezeway with an assault rifle and started shooting at the car. So again, the thing that's consistent in their story is what the person looked like and that it was one person. All right. Mitchell and Uten were armed at the time of the shooting, although both initially told law enforcement they were unarmed. Mitchell ultimately admitted to law enforcement that he had a 22 at the time, as did Uten. Although the detective did not recall if Uten said what caliber his gun was. A 22 could not fire a 7.62 or a 9 millimeter or 9 millimeter rounds, and ballistics evidence indicated that the 9 millimeter rounds were not fired by anyone in the charger. Okay, so all possibilities based on the ballistics evidence is that it wasn't fired by anyone inside. I don't know because the bullets were on the outside. But anyway, Mitchell and Uden fled on foot after the Chargers stopped near the field. They went to a friend's residence and called Hartfield. Mitchell and Uden contacted law enforcement the same day and told law enforcement that Smith and Hartfield were at the scene. Blalock and Ryan were arrested not long after. The lead detective remembered that Ryan was not very tall and had short dreads when he was arrested. Shortly after the police finished interviewing Hartfield, she contacted Appellant and Ryan through Instagram messages and told them that law enforcement had grabbed her and Smith. In the message, Hartfield said she had stayed silent and had told the detective she didn't know what happened. But Hartfield told them that Smith was snitching and had put the police on to Hartfield, and that the police knew about Blalock but not Ryan. Appellant replied that he knew the whole rat story, okay? Who cares? It be too much for me. All right. Statement of the case. On May 24th, a Fulton County grand jury indicted Blalock and co-defendant Ryan for participation in criminal street gang activity count 1, malice murder count 2, felony murder. It's a whole list of stuff, right? Um they got many years, okay? On October 1st, 2021, the court the trial court sentenced Blalock to life imprisonment for malice murder, 10 years for aggravated assault, that's count 7, to be served consecutively with count 2, 10 years for aggravated assault. So the aggravated assault will be on the other two people in the car, right? Um, to be served consecutively with count 7. 10 years for criminal. So it's to be served consecutively with count 7. So it doesn't say consecutively with count 2. Okay. 10 years for criminal damage to property to be served concurrently to count 7. And 5 years of possession of a firearm during the commission of a felony to be served consecutively to count 8. Count 1s and 5 were no pros by the state after the jury verdict. Counts 3 and 4 were vacated by operation of law. So when they say by operation of law, those might have been charges that were like something that was related to murder as well, but since they got the higher charge, they just vacated as an operational law. Appellant filed a motion for new trial on October 6th, right? So remember, they were sentenced on October 1st. So on October 6th, they immediately filed for a new trial, which was amended by new counsel on February 3rd, 2023, September 18th, 2023, and February 12th, 2024. Okay, after a three-part hearing in which the trial court heard testimony from seven witnesses, including trial counsel, as well as argument from counsel for both parties, the trial court denied the motion for a new trial as amended on May 20th, 2024. So that was earlier this year. Appellant filed a notice of appeal on May 22nd. This appeal follows. In his brief, Blalock raises three grounds of ineffective assistance of trial counsel. In that, trial counsel, one, permitted Tahira to invoke the Fifth Amendment rights in front of the jury. Two, that ineffective counsel was failed to fully object to alleged burden shifting. So that's something that was said that the prosecutor said in the closing statements about as it relates to um, the men not being able to prove that they weren't in the spot. But now I know where that comes from after reading this some further. All right. So, two, failed to fully object to alleged burden shifting statements during the prosecutor's closing arguments. And three, failed to put forth Instagram messages as evidence to disprove the state's theory of the case. Appellant also contends that these alleged errors, when viewed cumulatively, right? So it's saying, like, even if you deny that it was ineffective of counsel because they let her plead the fifth, they let the statement come in that shouldn't that the prosecution made an inappropriate Fifth Amendment statement. Even if you let all of those go, and that the defense counsel did not had an issue with the Instagram messages and didn't put those in as evidence, right? Even if you look at those three things and you say that it's okay, those errors, the three of them together, is just cumulative. And so that's the fourth reason. So still presents this in a way that if you don't like option one, two, or three, the fourth option is that the accumulation of these errors led to an error. Okay. Um. So Blalock also contends that these three alleged errors, when viewed cumulatively, require reversal of his convictions. Appellee, which is the state, submits that appellant has failed to demonstrate ineffective assistance under Strickland. So that's the case that everybody was quoting in here or citing. That is the that was violated. So Strickland. So they go on and make their argument as to why he had effective counsel. Um, Counsel is strongly presumed to have rendered effective counsel and made all significant decisions in the exercise of reasonable professional judgment. A defendant has the burden of proof to overcome the strong presumption that counsel's conduct falls within the range of reasonable professional conduct and affirmatively show. So, where we saw the lawyer where we got to see Mr. Wrong, which is Mr. Right, um, provide what I would think is ineffective assistance of counsel um, to Montauk. Not only when he signed the document and he didn't read it thoroughly, But then when we saw the follow up of what happened in the actual court case, right? That he now knew his client was gonna be in trouble, and then he got up there and testified with the same ignorance, which just showed us that he was not an effective counsel, even though a lot of people want to say that he was. And last but not least, we saw him on the day of the hearing, the revocation hearing, and how unprepared he was to really argue. And I say, from my perspective, the reason why Mr. Wright was unable to argue effectively for Montauk is because he knew that his services have been, like, he had poorly advised him all along. How do you argue something when you're the problem? And then you don't want to acknowledge that you're the problem. Um, Even though people think it was a beautiful order that was able to get Montauk out at the time of his mother's being real sick. That is all fine and dandy, but when you got to the next phase, you really needed to he really needed to do something differently. Anyway, on appeal, this court accepts a trial court fact findings unless clearly erroneous, but reviews the legal conclusion de novo. Now, you hear de novo used a lot. Further, this court has held that both prongs need to be addressed. So there's two things that you have to prove in order to prove ineffective counsel, and what they're saying is that the two prongs has not been met in this case. Trial counsel was not ineffective for permitting Tahira Hartfield to invoke her Fifth Amendment rights in front of the jury. Now, I don't know how they're going to all argue this and think that they're getting away with something. In this first enumeration of error, appellant contends that trial counsel was ineffective for permitting Tahira Hartfield to invoke her Fifth Amendment rights in front of the jury. The reason why I'm reading this, because again, this is the response from the Attorney General, a person that I was screaming that they should be going to the Attorney General with these inequities at the courthouse. But when you listen to this, maybe not so much. It seems like people that support the prosecutors and their actions. So I just wanted to put that out there. Um, Appellant, which is Blalock, argues that this continued invocation permitted the jury to use her silence against him, which is possible. And the reason why we know that this may have become an issue is because the jurors during deliberation had a question about the same thing. And they were given instructions. And that's what they're arguing. Um, so moving on into the document. Appellant, which is Blalock, argues that this continued invocation permitted the jury to use her silence against him because the witness invoked on critical questions that were adverse to appellant's liberties, right? Appellant further contends that trial counsel's failure to object to the trial court's instruction to the jury on the invocation also constitutes ineffective assistance of counsel. Appellee submits that appellant has not shown ineffective assistance. Just trying to point out there's there's more things at play in this little city, this little state of affairs. Appellant's brief um, contains a true and accurate copy of the entirety of the objection to testimony. However, the conclusions appellant draws from this limited testimony are not supported by the record. So let's see what they say. Mitchell and Uten, so technically, the attorney general should have probably argued this before the Supremes, because this definitely was one of the questions that were that came up. So here we go. The appellant's brief contains a true. All right. However, the conclusions appellant draws from the limited testimony are not supported. So Mitchell and Uten testified before Hartfield took the stand, and the basic facts were in evidence. The questions for which Hartfield invoked her Fifth Amendment rights were ones designed to confirm details of prior witnesses' testimony. None of those questions creating the obvious inference that Blalock and Ryan were the shooters. So who did it say were the shooters? Um, there's a thing here. To the extent appellant may attempt to argue a substantive claim of trial court error here, the claim has been waived because trial counsel affirmatively agreed with the instruction was proper. All right, so moving on. Notably, Hartfield actually provided testimony that was helpful to the appellant. Let's see what that was. On cross examination, she answered no when asked if she set up the victims to be shot or if she directed Blalock and Ryan to shoot them. She also told the jury that she did not know Mitchell Utner Holmes, nor did she go by the name Brazy. Although she knew appellant and Smith from school, which is appellant is Blalock. So she's saying she didn't know Mitchell Uten or Holmes. Although she knew appellant and Smith from school, she did not know Ryan. Hartfield further testified that people associated with the victims had threatened her, but appellant and Ryan did not threaten her. Whatever. At the motion for new trial hearing, trial counsel testified. So apparently they had a motion for a new trial, and whoever represented Blalock testified that she only realized there was an issue with Hartford invoking her Fifth Amendment rights in front of the jury when she talked to appellant counsel. So listen to how attorneys try to throw Steele under the bus, because that's who the appellate counsel is. Um, there was an issue with Hartfield invoking her Fifth Amendment rights in front of the jury when she talked to appellants. Yeah, that is. And this is from the attorney general who just put his 5 cents in on the thing. Uh, so let's just go back. I mean, everyone knows. I'm not even a lawyer, but everyone knows if someone comes and testifies and pleads the fifth, that is not the thing you want them to do on the stand, right? You don't want them to plead the fifth one time. Imagine them pleading the fifth several times during testimony, as Brazy did, even though she says she's not Brazy. Okay, so here we go. Thus, she reasoned that she did not have a strategic reason for dealing with Hartfield's testimony. However, the record demonstrated that trial counsel did want Hartfield to testify, but she could not ask certain questions given Hartfield's invocation of the Fifth Amendment. Further, part of trial counsel's strategy was to suggest to the jury that Hartfield pled the fifth, but she helped the real killers whom she was shielding. That was her trial strategy. And that's what she testified. So imagine you're filing an appeal. And you saying in your appeal that the counsel was ineffective, right? And then the counsel gets up there and testifies and she gives you her strategy and it sounds silly too. Okay, it is well settled. So this is what the Attorney General is saying. If it appears that a witness intends to claim the privilege against self incrimination as to essentially all questions, the court may, in its discretion, refuse to allow him to take the stand. Neither side has the right to benefit from any inferences the jury may draw simply from the witness' assertion of the privilege, either alone or in conjunction with questions that have been put to him. So basically, what that is saying is they don't want anybody to benefit, either side to benefit from someone saying, I plead the fifth. Because apparently, if a person pleads the fifth, it's going to benefit one party over the other. So they don't want either party to have that leverage. So they don't want to hear it. You normally don't hear that. Anyway, one reason for this rule is that reliable inferences do not ordinarily follow from a witness's invocation of the Fifth Amendment. I've seen different things written about people who plead the Fifth and what it really implicates or what might be implicated by the fact that they pled the Fifth. So it all depends on the evidence that's before you. Okay, so Davis versus State. Generally speaking, there is no harm to a defendant in a witness simply refusing to testify in the jury's presence. What is harmful is when the trial court allows the state, once a witness has invoked her Fifth Amendment rights, in effect, to testify for the witness and circumvent meaningful cross-examination as to obvious inferences. So, in that good old Constitution, if you're on trial, the defendant has a right to cross-examine the person on the stand, right? And if a person on the stand is pleading the fifth, then they don't get an opportunity to fully cross-examine the person, which means that you hear them say this all the time, like, oh, we didn't get a chance to do that. So that means that they are not able to confront. They call it a confrontation. They're not able to confront the witness. So evidence and circumstances can really dictate how effective pleading the fifth can be or not be. All right, so appellant must overcome the strong presumption that challenged actions might be considered some trial strategy. I don't know what kind of strategy that was. Despite trial counsel's assertion that she had no strategy after discussing the case with current counsel for appellant. All right, let me just read that again. Hold up. Appellant must overcome the strong presumption that challenge action might be considered sound trial strategy. Despite trial counsel's assertions that she had no strategy after discussing the case with current counsel for appellant and presumably hearing the argument he now raises, the contemporaneous evidence shows that trial counsel did have a strategy for not objecting to Hartfield's testifying and invoking the Fifth Amendment for most questions. So what the attorney general's office is saying is that, hey, listen, trial counsel is sitting up here. Well, appellate counsel is saying that trial counsel was ineffective. But trial counsel testified at the hearing for a new trial and said, no, I wasn't ineffective. I just wanted to, that was my strategy to let the person do that. That was part of my strategy. Someone could easily argue that that still is ineffective counsel because there is law, good law out there that says this is not, normal practice. That should not be a strategy. Anyway, moving on. So basically, the attorney general is pointing out that, or is trying to make or bring the court's attention to the fact that this is a strategy for the appellate counsel, but it was not a strategy. What I would have thought would have been a better approach right now for both counsel, right? Appellate counsel, which is Brian Steele, and the counsel for the young lady, is if, the trial counsel, I don't know. I just think trial counsel finds herself in a difficult position because at this point it's saying your job as defending this defendant was part of, you didn't do the best job that you could have done. But my question would have been, did the defendant understand what was happening at the time things were happening? Anyway, so moving on. So that's one issue that they've come to put their own twist on. The contemporaneous evidence shows that trial counsel did have a strategy for not objecting to Hartfield testifying and invoking the Fifth Amendment for most questions. Trial counsel wanted Hartfield to testify. Hartfield testified favorably to the defense when she did answer questions, and trial counsel was able to utilize Hartfield's invocation to further the defense strategy. Trial counsel's decision to not contest Hartfield's invocation of the Fifth Amendment in front of the jury was made in the exercise of reasonable professional judgment. Okay. The key word there is reasonable professional judgment. And that is where I stopped. Because here I was calling for the Attorney General to look into these things that are anomalies in the world that I live in. And here I'm reading that the Attorney General is finding that this stuff is reasonable professional judgment. If most people will not allow somebody to plead the fifth, right? That's what a reasonable attorney would do. Why all of a sudden would the Attorney General be backing up this and calling it reasonableness? It doesn't make sense. It doesn't pass the sniff test. I don't think it will hold up either. I don't think the appeal will hold up too well under the claims asserted. I don't think so either. Because I think if they get a reverse, and because I was listening to people on YouTube and I had to go listen to it for myself and had to go read things for myself, this is just asking for a new trial, right? Which probably they should get is a new trial. But if they get a new trial, um, the second issue that is about the Fifth Amendment. Not the first one is about pleading the fifth. The second big issue that was presented to the appeals court was the issue about closing arguments that the prosecutors made an assertion that they're not going to tell you where they was at, or that they was someplace different, or it was burden shifting, right? But we all know that what lawyers say in the closing arguments, in their opening statements, are not facts. There, the jurors are the people that determine the facts. So here we go. I think I'm over it with the first count. So I'm just gonna breeze through that and go to the second one. The second issue was that here there was also a strategic there was a strategic reason for counsel not to object to the court's instruction. Trial counsel argued that the defendants were not present for the shooting. Hartfield and Smith had clearly set this thing in motion. It should matter to the jury that Hartfield and Smith were not being held accountable. So basically, the strategy was to paint the picture that it wasn't the two defendants that was on trial who should be held accountable. It was the two women who were in the car, or who. So that was a strategy. And by letting her sit up there and plead the fifth, she was in furtherance of that strategy, saying like, "Hey, Hartfield, Hartfield was the person. Yeah, Field, Hartfield. Hartfield was the person that she pled the fifth because they are the people that were there." And I think you can't, even though in the appellate brief, they were very clear to say that there's no evidence that puts Blalock or Ryan at the scene outside of um, Smith. Smith is the only one that puts the two of them there, because the two men who survived the shooting can't identify the shooter beyond the fact that he had on a hoodie with long dreads seeping through the hoodie. Openings, closings are ops two opportunities to spin the tail. Then again, didn't still object during Love's Jungle Book opening. Um, he object, but not to the Jungle Book. He object to the PowerPoint. At my understanding, he object to the PowerPoint that was being displayed for the jurors to see. It had that he was handling this appeal, had something with his name and appeal associated with it. And according to Steele, he was not the appellate attorney for Ryan. So it was misinformation that was on the slide, and it related to him representing one of the people. It's what the slide had in it. Here, okay, so these arguments suggest that Blalock and Ryan were innocent, and Hartfield invoked her Fifth Amendment rights because she helped the real killers. Trial counsel confirmed that part of her strategy was to suggest to the jury that Hartfield pled the fifth because she helped the real killers, whom she was shielding. This is a sound trial strategy and an objection to the trial court's answer of the jury question would have run contrary to the strategy. Trial counsel wanted, and he emphasized wanted, the jury to factor Hartfield's silence into their deliberations. that the jury may have factored it against the appellant isn't of in his favor does not mean that no reasonable attorney would have done the same. Now, this is where I get to ethics. This is where I get to ethics because what reasonable attorney? So this is like why I would think that the ineffective counsel thing kind of works here because what reasonable attorney will come up here and this is like a lie, present misinformation or mislead the jurors like this. It's just crazy. It's just this. It's just crazy. It's just crazy. Anyway, uh, uh, so that the jury may have factored it against the appellant instead of in his favor does not mean that no reasonable attorney would have done the same. As appellant what has not overcome the required presumptions under Strickland, he has failed to show the trial counsel was ineffective here. As such, this court should find that this enumeration lacks merit. So the first one about the Fifth Amendment, pleading the fifth, lacks merit. Here we go to issue number two. Trial counsel was not ineffective. So they start theirs with um, why they are against whatever Steele wrote in his. So it says trial counsel was not ineffective for failing fully failing to fully object to alleged burden shifting statements during the prosecution's closing argument. In his second claim of error, appellant contends that trial counsel was ineffective for failing to fully object to the prosecutor's comment that appellant did not explain where he was at the time of the murder. So that's what the prosecution said in its statements, that he didn't explain where he was at during the time of the murder. Specifically, appellant argues that although trial counsel objected, trial counsel did not frame the alleged error as an intentional comment on appellant's failure to testify of post arrest silence. For the following reasons, appellant has failed to show deficient performance or prejudice to satisfy Strickland. At issue is the following portion of the prosecutor's closing argument and the argument regarding it. So let's hear what the prosecutor actually said. The prosecutor. Oh, let me brace y'all. Just be prepared. Okay. I'm going to sit down in a second, and I believe co-defendant Ryan's counsel is going to get up first, and I believe trial counsel, well, they don't have to get up if they don't want to. But I think they're going to. No different than anything else. They carry no burden in this trial. As they are talking, I want you to listen for an answer to these two questions. And these are two questions that have sort of been sitting up there, I think, for me this whole time. If they were not committing the murders, where were they? Now, this is the only thing that I truly think is what they're considering on appeal. Okay, so co-defendants Ryan's counsel, judge, I object to burden shifting. Trial counsel, which is going to be Blalock's counsel, I would object, Your Honor. They don't have the burden to prove where they were. Prosecutor, judge, I won. What the attorneys say in closing is not evidence. Two, I prefaced it with the fact that they carry no burden. And three, I also said they do not have to answer this question. So, based on those responses to the objection, is why this is the strongest one that I think the um could get the reversal. Judge overruled. So the objection wasn't sustained, it was overruled by the judge, which means that the judge was even in agreement that the prosecutor could say that. So the prosecutor goes on. If they weren't committing the murders, where were they? So now, after you done got this overruled, you gonna go dig back and get harder. They are both saying it wasn't they weren't there. Tell us where you were. We didn't hear any evidence of it, obviously, but I would still like to hear that answer. Okay, trial counsel. I would object again, Your Honor. They, that's sustained. Well, you see, Judge, you just let the person go in and get it over with and see what happens. Thank you, Judge. That's the prosecutor. Thank you, Judge. Thank you for letting me still put it up in there, knowing that I shouldn't have said it in the first place. Okay, now in a minute, they're going to get up and they're going to talk to you again for however long their side takes to tell you what they think the evidence shows. And then I'm going to get up and it's going to be a pretty long time for me to get up here and explain what we carry the burden. So we have to show you everything. We can't hide anything. We can't put anything aside. Blah 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 blah. So my second closing. So basically, she put seeds into the jurors' ears, like, "Hey, this is something that you should be considering, and you should be listening for this." I'm gonna let them just speak and tell you whatever it is, and then I'm gonna come back and tell you the facts. So let's go. It is well settled that the making of objections falls within the realm of a trial tactics and strategy, and thus usually provides no basis for reversal of a conviction. So what they're basically saying is the failure to make objections in a certain way usually provides no basis for reversal. Here, the record throughout trial demonstrates that trial counsel considered objecting, actually did object, and even had one of her objections sustained. The record itself reflects clear strategy by trial counsel. Neither the fact that counsel could have pursued a different strategy, nor the fact that her chosen strategy was partially unsuccessful necessarily renders her performance constitutionally deficient. So, what they're saying is just because she picked the wrong strategy and it didn't work in their favor at the end doesn't mean they get a do over, is basically what the attorney general is saying to the defendant. And trial counsel's strategy was not unreasonable merely because appellate counsel would have pursued a different strategy. So notice the hits that they're putting into still. Like he's saying, just because this is not the way you would have tried the case does not mean that it was ineffective. This was this person's process. They're expecting these overly zealous attorneys to present um, especially in a case like this where this probably was a public defender. Um, I don't know what Blalock had, but whoever he had, and I think the person that we can clearly see people trying to be willy nilly on court strategies are people like Mr. Wright, Attorney Wright. You understand? They've been wiggling through this system for so long, they just think they could do anything. And this person put together a strategy that just, according to the attorney general, didn't benefit her at the end. Further, this argument did not, as appellant claims, exploit the fact that appellant did not testify or introduce evidence to support his theory or defense, nor was it impermissibly burden shifting. Instead, the prosecutor merely noted that appellant had the ability to present his own evidence to rebut the state's evidence and support his theory of defense, but did not do so. Then I think one should have said it like that and not said where were they at. Ask yourself where were they at. A closing argument is to be judged in the context in which it is made. What is more, a prosecutor is granted wide latitude in the conduct of closing arguments, and this is the reason why I'm, just giving this some attention today, because people are going to be, if we get past directed verdict and some of these charges get to go before the jurors, you're gonna see a lot of disposturing from the prosecutors in this case, and I just wanted to prepare you for that. A closing argument is to be judged in the context in which it is made. What is more, a prosecutor is granted wide latitude in the conduct of closing argument, the bounds of which are in the trial court's discretion. Within the scope of such latitude is the prosecutor's ability to argue reasonable inferences from the evidence. All right. You can argue reasonable inferences. But hello, Attorney General. All of these attorneys down in Fulton County, they are making up their own facts and coming up with their own opinions. You can go right to the murder of Drinks, and you can see where, not having a thorough investigation, these people rendered their own conclusion. When you can see that car number 4 makes a Yui to get away because car number 3 might be doing the damage. But I still feel like car number 3 knew car number 1 and 2, okay? But nevertheless, the person that actually did everything was car number 3. Anyway, that's just one example of what we saw recently. Then there are so many other examples where you listen to them, they've listened, they've eavesdropped. An eavesdropper ain't never heard nothing good. They eavesdrop on conversations, and then they want to tell you that that's what it meant. It meant what they said it meant. I just, even if a person tell them that's not what it meant. Hey, why you sent the girl a brain emoji with a rat? He said, I don't know how her brain worked like that. Like, what's wrong with her brain? That's what he said it meant, right? See, I never understood. See, I know what a rat is, right? And if it was just the rat emoji in and of itself, right? But it had the brain there. So I was just like, what does the brain mean? He came out and said what he said the brain meant. It is well established that while a prosecutor may not comment on a defendant's failure to testify, listen to how they stretch that piece, right? That he's not testifying. That's the same thing of he's not going to tell you where he was at that time in the morning. He may argue that evidence of guilt has not been contradicted or rebutted, where directed at defense counsel's failure to rebut or explain the state's evidence. Like in Jackson here, the prosecutor reminded the jury that the state has the burden of proof prior to the alleged burden shifting statements. Oh, I didn't see that part. The prosecutor merely pointed out that the petitioner could have omitted evidence to rebut that which the prosecutor admitted. As these comments were not impermissible, appellant cannot show that trial court acted deficiently by failing to object with more specificity, nor that there was prejudice from the prosecutor's comments. It is well established that counsel cannot be ineffective for failing to make a meritless objection. The failure to make a meritless objection cannot amount to ineffective assistance. As such, this court should find this enumeration lacks merit. All right, moving on to situation number 3. Trial counsel was not ineffective for failing to put forth Instagram messages as evidence to disprove the state's theory of the case. So now they said that they could have put it together. So in one essence, they're saying that the counsel should have put forth these Instagram messages. And they're saying no, by not putting them up didn't hurt or help. Here we are. In this third enumeration of error, appellant argues that he received ineffective assistance of trial counsel due to counselor's failure to introduce evidence that the victim returned fire. Specifically, appellant contends 2 things. 1. Mitchell's Instagram records introduced by the state at trial supported appellant's theory that there was only one person shooting at the victim's vehicle, and appellant was not present at the scene. So what they're saying is that Blalock was not there, and Blalock was not there. Now notice when Mariah testified, Mariah the liar, in the instant case, right? She was very clear that she saw Little Rod. She didn't move a muscle on seeing Little Rod. Okay, number 2. Had trial counsel been familiar with these records, she would have shown the jury that the state's theory was incorrect and challenged the credibility of the contrary testimonies of Mitchell. Now, one of the reasons that you can appeal something has to be, how do they say it? Like, you can appeal new evidence, but there's parameters that you can appeal when evidence was presented and you had the evidence and you didn't use the evidence that was available to you at the time, opposed to new evidence that should have been available. So you can appeal based on new evidence that wasn't available at the time but is now available that would probably yield a different result, right? opposed to having all the evidence and not using the evidence. This is like when you get the discovery, but you don't go through the discovery thoroughly, and then you're screaming at the prosecution, well, you didn't tell me which discovery you was going to use. And I keep saying you have to look at all the discovery and determine what you're going to what you would use out of the discovery they've given you, and not just worry about they didn't tell you what discovery they're going to use, so you don't go through the endless amount of discovery. So, um, she should have shown the jury that the state's theory was incorrect and challenged the credibility of the contrary testimonies of Mitchell Smith and Detective Hogan. Appellant has not shown prejudice as to this claim. Trial counsel testified, so this is again for that request for the new hearing, right? So the trial counsel testified that she did not recall seeing the specific Instagram messages, but brace yourself. Brace yourself for it. Brace yourself. But there were thousands of pages of text messages in discovery, and trial counsel went through them as best as she could. After the expert testified and the Instagram records were admitted, counsel reviewed them again to look for something that had been missed but did not recall specifically reading the messages. Appellant now contends would have disproved the state's theory of the case. She admitted, after having reviewed the messages, that they would have been helpful to the case, as the messages state that there was a shooter outside the vehicle and a shooter in the vehicle. She testified in hindsight that had she seen the importance of the messages, she would have used them at trial. The two relevant messages are one that blamed Mitchell for the victim being killed, and Mitchell's response that he did not let the victim be killed and shot back. The trial court found that trial counsel's performance was deficient for failing to find the text messages in the discovery that was provided to appellant. However, the trial court found that appellant was unable to show prejudice, given that the two relevant messages may have opened the door to evidence of gang involvement that had been barred by the pretrial ruling. I wonder why they didn't do gang involvement. Were they already planning for this RICO at that time and wanted to indict and convict on these charges so that these charges would become overt acts in the RICO? Because remember, these charges for this particular MDK was what do you call that stuff? It became the other stuff. It became an overt act. Okay. That they had been barred by a pretrial ruling, and the trial testimony was replete with testimony about Mitchell having a gun and whether he fired back. All right. At trial, Mitchell testified that his gun was not loaded, he did not fire at anyone, and he didn't see anybody in the car firing either. As the trial court found, appellant has not shown prejudice. It is undisputed that the messages would have shown that Mitchell was in a gang, as the screen names of the two individuals included street gang references. What gang was he in? Like, I need to pause, 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 pause. Everything moving around all of these players is part of a gang. So, how do you, in some instances, protect victims from mentioning that they were part of a gang? We started out this court case here with the YSL not wanting to say anything negative about Donovan Thomas, right? I am sorry. Sometimes people find themselves in a murder, death, kill, right? MDK, based on how they lived. You can't rewrite the story. Doesn't mean that they don't deserve justice. If you try to hide the facts and close them up and keep them away from people, you're never going to be able to get justice. You are ultimately saying, this is what you're saying when you don't want to disclose the truth to the jurors, right? You're saying to them, listen, I don't want you to know that this person does bad things too and deserve to live. That's basically what you're saying when you don't want to be honest with the people that have to make the decisions. Everyone has the right to live. And as a prosecutor, your responsibility is to, if you can present a case that will find justice for the elimination of that person, then you should prosecute with that endeavor in mind. That you are just seeking justice for the act that was done in your community against a member of its society. And the reality is, we live inside these worlds, right? We live in a community that has good doers and bad actors and good actors. We would like to think that good actors outweigh bad actors all the time, but that's not necessarily what happens. But you can't go around hiding from the fact that a bad actor got taken out, because the reality is, to this one group on this side of the fence, the bad actor, the person that got taken out, was a bad actor in their eyes, but to the people that loved that person, they were a good person to those people. And it's going to be vice versa on the other side. So the best thing that you could do when you're trying to have law and order in your communities is distribute your prosecutions evenly and across the board. In order to be a no nonsense tribunal, you have to be willing to administer that tough love across all facets. A lot of people are upset with what happened with Montauk and the judge, and how she came down on him for 5 years and said she amounted his violation to perjury, right? And perjury is punishable by this amount of time. Listen, the problem in Fulton County is that they have punishments. The punishments are too severe. The recidivism is up because the way in which they are administrating the consequence has no deterrent in it, and it has no rehabilitative factors in it. Obama just testified this week, right? We all know he was somewhere shoplifting, looking like an Ethiopian up there. Him hungry. He was trying to get some food for himself, right? At the end of the day, the struggle is real. They ask him, you're happy that you're out on the street, right? Is he really happy that he's out on the street? If you're out on the street and you can't survive, why do you think some people go back and they commit more crimes and they repeat the cycle? It's probably better in there. While they're highlighting and everybody's running around talking about this report that came out of Rice Street, everyone's known about the horrors of Rice Street forever. It's not the question of, hey, we got a report. The question is, what are you going to do about the report that you've got? You understand what are you gonna do about it? Millions of people. I looked on. I came on YouTube on Friday, And all I kept hearing was one stream after another stream of people just talking about what happened, what how deplorable the environment was. Hello, we saw PC, right? We saw a video from PC when they tried to get at what's the dude's name? YFN Lucci, right? We didn't see that dirty court. We didn't see. We definitely wasn't in that side of the jail where YFN Lucci was coming. Um, was in that report. You understand? We saw deficiencies, negligence in their policy where you got a guy testifying on the stand talking about they're out one at a time. And then we can count like four inmates or four incarcerated individuals walking around at the same time while you tasing people. The bottom line is the reason why the gang situation is so severe in Fulton County, based on my observations with this trial, is that the penalties are too steep. The mechanisms to prevent recidivism are not in place. The monies allocated for gang prevention actually built the whole gang community. The very monies that they put in the community to protect the generation that was this YSL, right? This started when these kids were in their youth. And they had the money then to do preventative measures, right? They knew the generation before them had already been lost. This is probably the generation of their parents that they already knew was a problem. And they were supposed to prevent this group from even coming to this situation that they're in now. But instead, they use those resources to educate further whatever this lady's name that was just testifying, Velveeta, right? Who was just on the stand on Friday and will return, on Thursday and will return. The system, it's Fulton jail system is gladiator school for criminals. So even if you go in there for minor charges, you leave forever changed, usually for the worse. A lot of these people were probably jumped into this same gangs while they was up there incarcerated in their facilities, right? I read somewhere, I was looking at somebody's stream yesterday, and people were upset and they was like, "Oh, I heard that they put a 17-year-old in there." Hello. Most of these men that testified in this trial, they have been hitting those bricks, those Fulton County bricks, since they were minors, since they were juveniles. You understand? When you look at little Rod, he's been in there since he was 15 years old. He went from the juvenile side of it to now the adult side of it. He probably turned 18 in one evening, and he turned it at 12 a.m. They probably were already shipping him over to the other side of the equation. No, it's not. I remember on this channel covering that man that died with the from the infestation. I remember covering that, but I covered it from a perspective of not knowing how bad this was, but covering it from the perspective of mental health being denied the appropriate provisions. Same reason why we have this trial in New York currently, where a mentally disturbed individual is on the train, and another man who's not familiar with the culture of New York, because the bottom line is New Yorkers get on the train and they mind their business. Okay, there hasn't been any. Let me just say this: panhandling, just like on the internet that you can't control, people that panhandle, panhandling happens on the train, right? Nobody goes and chokes out the panhandler. And the people that are testifying, especially the women that are testifying right now, are making a big deal like, oh, I was so scared and afraid and all this other stuff, that you sat there and watched a man's life being dragged, being taken away from him. I can't with the hypocrisy. I just can't. From COVID, we had 2 years of people who had probably before COVID some kind of mental support. Only to um what I'm saying is that he he reacted in the way that he reacted based on whatever training he had, which is which is contrary to the way everybody else would have responded on that train. He didn't feel, from what I understand, he didn't feel any personal threat. He was in protection of others, and and that's about it with him on the thing. I can't get to that trial because I'm swamped with stuff at work. And even when I was down in that area, I didn't have time to leave what I was doing to be nosy over there. Cause if I could have, I definitely would have. Little Rod was in Rice Street longer than he was in school. Little Rod just had issues all the way. And do they have school services available? In and so in the prison, right? I know in New York, in incarcerated individuals or the youth, I don't know what they call the youth when they're incarcerated, they are given the ability to continue in their school resources. But the problem is this gang stuff is so prevalent that they can't, most of them can't even finish what they got going on academically because they begin to protect themselves from the minute they walk in the door. So from the moment that they walk in the door, what's up, King of Foe? Um, that's just, it's a this whole thing, when you look at it from, it's just sad. I don't know what else to say. It's just sad. Moving on. As the trial court found, the appellant has not shown prejudice. Um, it is undisputed that the messages would have shown that Mitchell was in a gang, as the surnames of the two individuals included street gang references. Any questioning of the defense about these messages could have potentially opened the door to evidence of gang involvement. Additionally, the two messages in question essentially show that Mitchell was defending himself from an accusation by another individual, and at best it would have been used as impeachment for his trial testimony. The messages show that Mitchell twice claimed that they were shooting back, which served to imply that someone was shooting at them first. Okay, listen. Let me just tell you this to be very clear. People, the problem with with all of these cases that we're seeing in Fulton County is that they're not telling us the whole story. They're telling us some of the story and partial in part. They're bifurcating out the truth. Everyone had a right to know what was truly meant, because see, Mitchell and Uten, right? They left, man down, people are forgetting, they left Holmes in the car. abandoned the car and ran to somebody's house to tell somebody that they got shot at. So I'm gonna need people to stop, drop, and roll for a minute. These dudes left a man behind. So when they was up here on Instagram trying to defend that we shot back, right? Either they shot back and they lied to the police that they didn't, or they didn't shoot back at all and they left their man out there to die. And there's a consequence for that action. The bottom line is when you join, there's code of, you know how they have these professional codes right here? There's codes of the hood. And for prosecutors to be sitting up here and trying to act like we're not gonna put that forward because we don't want to show the bad side of it. The bad side of it, this is the consequences. This is what people need to be really seeing and really hearing in real time. Because the only deterrent is really providing people with the full, complete story. That's why there's a thing of completion. If they were to provide completion, some of these people will walk away from some of the activities they are dealing in. Um, um, we have watched the DA act in furtherance of. I don't see. I find it is so. It's particular to me that there is some gangs that seem to be protected in this infrastructure of Fulton County, and other gangs are ostracized or put in the limelight for what they do. In the Northeast, we do attempt to educate our prisoners and folks stuck at awaiting trial. Yes, I will have to admit that we do. In especially here in New York, I can only speak to New York. I really even can't speak to New Jersey because I don't really understand their processes in Jersey. But in the New York area, we do try to we do try to educate. Yeah, you can clearly see in this case that there is a group being protected. But I wondered, like initially when I was listening to this, I was looking at the neighborhoods, right? These people lived in houses, these people came from project settlements or whatever. And then we got to look at the boxing chick, and she came from an environment that was she came from the other environment where she was living in a townhome, right? And she started to date the other guy from the other side, right? And then I was up here thinking like um another Smith at that she was, even though she spelled Smith Smith. I don't even know what kind of Smith that was. So you could tell that she was nervous even testifying. I want to give her that much. But treat all the treat all the criminals the same. There should be no deference. Um, Additionally, the two message, but I understand why they would have argued against the gang Instagram for Mitchell and stuff, because see it's hard because they're not painting a true story to really tell. Even if I'm part of the even if I'm part of people that are doing the wrong thing, right? I still have a right to live. Did you put the wrong name up there? Girl, don't even start with me with that. Additionally, the two messages in question essentially show that Mitchell was defending himself from an accusation by another individual, and at best, it would have been used as impeachment for his trial testimony. The messages show that Mitchell twice claimed that he was shooting back, which served to imply that someone was shooting at him first. You know what it is? Because I really don't want to get on the Mr. I really don't want to get on KB today. Because you know why? Because I listened to the interview yesterday between, so this is a pause moment. I did watch Sylvia's interview with the I'm in love with the stripper. And this is what I think is going down. This is my new theory. So based on the information that we got so far, let me take you off of here. Based on the information that we got so far, I'm at the point of this is where I'm at this moment with this married thing. So we know it's affirmative, right? We know that's an affirmation. We know that is what happened, right? But here's the thing. The question is why. I'm still of the belief that something more sinister is going down and the person is trying to protect themselves. But I'm also got to put my hoodness into this, right? And come to the realization that a couple of weeks ago, people thought that they was going to get off, right? So I really think that people are trying to manipulate the process at this point. I didn't even, yo, I was going to make a live stream, but somebody already had put out a couple of days ago the sister wives things. Um, but it has to have some. You know how they have law and order. Like this is like there's another dude that got like hood and order or something. I forgot what that other guy is calling it over there on his channel. But here's no, because the person to really have been protect, the person to want to protect would have been the stripper. So again, I still go to self preservation, and I feel like um I feel like people thought Shannon was gonna get free, and if he was free, what they were gonna negotiate as part of their long plea negotiations, just like so. Let's go to Thug. I feel like in Thug's negotiation, I'm in love with the stripper. So in Thug's negotiation, I feel like he just openly said, um, I need a way out. Listen, he done took his childhood home, okay, and turned it into a place for people to lay their head. And see, for to some degree, I believe that. I believe that, and I could be naive, but I'm just gonna tell you my beliefs. When I listen to Obama testify, see, I I believe he was telling the truth when he was talking about the purpose of that house that she was pointing out, and when he said he rented the house for us, but that was Thug's home where he grew up at. I'm gonna need some clarification on that or some verification on that, right? Nobody hit the YouTube what do they stop doxing to see if any of that was true. But nevertheless, right? Hilton stood up there and was like, "Well, y'all was using it to sell drugs, right?" So he said, "Well, I sold drugs." I like at this point, it doesn't even make sense for Obama to tell the truth or tell his truth in the words of the other dude because it wouldn't have mattered. because whatever he said in the paperwork is all that's going to matter. And he's already been picked up for shoplifting, and no, he's got a date, right? Which should have been 10 days after he was put on notice that they wanted to revoke him. But he ends up in trial testifying over here, right? So that is something to further keep him on the streets. Let me see. No woman I've ever wait, no woman. Well, all right, wait, let me go back up. Let me before I get to any woman you ever dated. The girlfriend is impressed about it. She knows what it is. It's game. It's game. So Kayla moves to Texas, and she moved sometime during the time, or was officially moving sometime during the time the stuff was going down with Woody. People have reported that that wedding certificate request was put in since March. She represented Woody in June, for whatever reason it was. Even if you was dating this dude, you should have never represented Woody. Period. But that's just my opinion on conflicts. She doesn't feel she had a conflict because that wasn't her client. He was your client. You was trying to get him to sign a paper to free Melnick. You understand? Nastiness around there. But in any event, by marrying him, she lives out of state. He's probably seeking some kind of out of state, um some kind of out of state probation, because especially with this last crime that we really can't prove that he did, and if they let him go on or release him from the Donovan Thomas crime, right? If he gets a directed verdict on that, and that doesn't even go before the jurors for consideration because there haven't been enough evidence to put him there at that scene of that crime, what'll happen is he still would need to be out of Atlanta. Uh, you can't get people to do it willingly, so you get people to do it, strategically. All right. Oh yeah. So, but she said she was shooting with her eyes closed. She said she was so scared she was shooting with her eyes closed. I heard it all. I don't think she was playing about the sharing. But when I looked at the picture, somebody else put up like a picture, like a picture of her and a picture of Kayla on the same thumbnail. And I was saying to myself, he definitely got a type. The same way that Scrippa got a type, he definitely got a type, because when I was even watching her speak and how she turned her voice, they all sound the same to me. Now I know they come from the same hood, the same neighborhood, whatever it was, but they definitely had a lot of things in that were favorable, right? Both of them look like they have their own stream of money. Not that I'm saying he's codependent or codeficient on somebody else. I'm just saying they seem to be people making bags on their own. They're not in need of anything, so he's not overly doing anything. If you will remember, he was getting picked up and taken to the house to babysit the child when he was being put in. Well, I don't like to say when a man is watching his child that he's babysitting, but being taking care of his son. The other girl was picking him up with her friend when they got caught up in the mess up. I do too. I'm more. You know what it is? Um, it's Shannon don't need that hair. Oh, we could talk about people over here. Shannon don't need all that hair that he got. It's not helping him. But Yak, either way, with all the hair, whatever, I found him to be an attractive young man. And I also find for something about Yak just makes me think that he's so much smarter. But I'm not against Shannon at all either. I just think that some people are some people just letting them do all kinds of stuff right now. Girl. But I will say the same thing. When I was listening to them tapes, I was like, what's wrong with Shannon? But it's been for weeks now that I've been under the impression that the real leader of the gang was Shannon. I think the moment he entered the prison and they put on that call when he was like boppity boppity boo biggity biggity bop, and them guys was like, what's the word for the day? And it was just like, leave your hands off of him. That let me know he was the man. Um, like it just I'm not confirming. I'm with you. I'm with you. I haven't seen all the women that he dated, right? But I think that was I, I don't find. Um, I'm with you, Becky, and you know Becky be getting me in trouble around here. I'm with you, Becky. I'm with you, but I've never. Let me tell. I'm just not a Kayla fan. I'm not even gonna hold you. He down with the dark child. They wasn't even dark. Nothing's but nothing's wrong. Let me just be clear, right? I don't like Kayla's. I don't like Kayla. Period. Right? It's how she rolled up on the scene. I think the moment that I disliked Kayla was the moment I saw her trolling inside of that guy's chat. He's a lawyer on here. Talk law, let's talk law, young dude, whatever, whatever. And she went over there and she got on his platform and she inched her way and I watched her maneuver on the YouTube space. So I didn't like her for that because of who she was representing. I didn't like when Mama Dearest came out to defend her, which is what Mama Bears do. They defend their own. I just realized in real time that Kayla was messy with the capital M. And then when she went, it just trickled. So nothing surprises me here. And that's just where I am with her. Just nothing surprises me. Um, I'm not really I'm not really intimidated by him. I just feel like I still have the question why they put into evidence the picture of him looking outside the window. Um and I just wonder if they did that, if it was a, in the words of the judge, right? When what's name was like subliminally, if it was one of those um secret messages that the prosecution was sending to Shannon as to say to him, you see that day when you was looking out the window, your life has changed every moment since that day you was looking out that window. It's been like that, like that day when you was looking out the window in the penthouse, your life has never been the same since then. What direction it goes in. I can't with you. Um, it's first of all the stripper, right? She gave off vibes to me like, so in the hood, right? There's your down girl, right? Like she's that down chick, right? Like she was bringing. I just got the whole like I just saw like a whole nother world of them. Um, no. But see, they had something going on. That's why I was gonna do the Ricas, right? The women of Rica. The Ricas is killing us. Yo, that trench coat when he's standing there with the whole like, I'm just like, you can't talk to me with a switch. I'm sorry. Um, you're so stupid. You is so stupid. You definitely gotta be on a life of like, I'm doing this. I'm doing this. Um, the bottom line of me reviewing this appellate brief is this: listening to other YouTube channels that I thought was here before me covering this a little bit more intimately than me, I thought they was onto something when everybody was screaming from the top of the roof that these guys are going to be that the appeal is going to go forward. They both got the life sentence for the murder. There's a possibility based on descriptions. I don't know what Blalock looks like. I don't know if he got dreadlocks, but this is what I will tell you. If at the time of this incident he had dreadlocks, a hoodie, and was tall, he's the one with the he's the one with the big boy, right? He came out with the big boy on the scene, right? Um, because they definitively say that Ryan wasn't tall. Okay, here's the other thing um about the situation with Ryan, which is the unfortunate thing about everybody that is an accomplished with someone else, right? When you roll with someone else, you get charged for the same thing that the other person gets charged with, and you do the same time, even if you were not a participant in the actual incident. So it's in those cases when you have to come out and you have to sever your relationship with the person if you ever want to see the light of day. So when Judge Witt gave him the 10 years to run consecutively, I'm sure they understood what this appeal was about. So I hope if this is the best that Steele could come up with for these people, that's going to be interesting. Now, I know that one of my girlfriends was telling me to not have weight in the people. And I was assuring her that I hadn't picked sides on who's the best attorneys here or whatever. Because a lot of people are looking at Steele's record and saying, okay, how are people going to feel in a couple more weeks when he's going to trial for the prosecutor who, in the Ahmaud Arbery case, was willing to let Ahmaud Arbery's killers go free by saying, don't even look at them, don't even indict them. And he's representing her in her case. So how are people going to feel about that? So I was like, no, I've been over I've been over these attorneys for the longest time um on this case. I just been I've been so over it. Sounds like we need the mystery machine Scooby Doo for that catcher. I don't think Shannon is gonna be with the lawyer. Um, I don't think so either. I think I honestly think this was a play. What the play was about, I don't know. Um, I don't think that anybody would just in court papers would just let you file fake court papers all over the place. So I think that part of the play is real, but the intentions behind the play, um, I've had people ask me like, is he a U.S. citizen and stuff like that. I really don't know. Um, Trying to look for reasons not to be deported and stuff like that. Yeah, I do try to look at the motions. I do try to look at the case in from a real perspective. And I try not to go and do what this how I feel about this internet. I can go and duplicate what other people are doing out here and just have the same content. Or I could just come out here and just talk about it from my perspective and just have my perspective on it. And I'd rather just do that. I could go in other people's room and listen to them do the same type of content. Well, I'm trying to figure out um, who's gonna get the big bag from like, is this gonna be a Netflix? Like, who? Because this is not gonna make a Lifetime movie. So what does it make? You know what though? That's what I thought was gonna happen. But instead, they ran into like when I heard Shard telling the story about how his client got arrested during a goat sacrifice. I honestly thought this is what I thought. I thought the man got arrested during a goat sacrifice. I had no idea that the man was running from Chick fil A. So he was in a chicken sacrifice, running from the Chick fil A, trying to get away from the police. And yes, they ran. And the reason why they ran is because they had stuff on them that they didn't want to get caught with on them. But I don't believe I honestly a part of me wants to believe that they didn't know at all about the dude in the car, right? I want to believe when they talking about he took off and was doing 70 down the block. I want to believe that he was doing 70 down the block because he saw the car rolling up fast on him and he thought that car was going to chase behind him. And that maybe when he went through the light, he heard the pew pews behind him and it made him just run and dash, right? That's what I want to believe based on what I saw. But I don't want to be as naive as Hilton and just put my own narrative to it because I seen a couple of things. But that's what I want to believe. Um, I kept asking you peoples if they were Haitians. Hey, do you know there's things that people do? Puerto Ricans, Spanish people do chicken sacrifice. Chick fil A. I'm just saying. They made it think like they made us think like they they had us thinking that homie like I'm just saying this with Chick-fil-A and catching strays. I don't know. They was all in. Imagine this. You at the Chick-fil-A getting you some. You ordering your meal, and they got a bolo out on your vehicle, and the police officer there getting his Chick-fil-A on and sees your vehicle. And stuff is just crazy. What are you starting to think? But Shard made us believe. You know what though? If it's on Netflix, right? It's gonna be some in-depth look into. It's gonna be some in-depth look into how those lyrics really were about the crimes. I'm sorry, cause that's the only way mainstream is gonna want to have it, right? Because they are probably looking at this stuff, this freedom of speech, thing, and saying to themselves, we need to really distinguish between freedom of speech and in furtherance of crimes. Now there is something there's something real about telling, like, people for years have been writing books, and in their books they tell stories about fictional tales about stuff. Hold up. I don't want it facing me. Okay. They tell fictional tales about stuff, and it's not it's the it's gonna come back around about those lyrics, and it's gonna be how the lyrics really stuck, really sunk all of this rap music. You know, I haven't read the book yet, but what I do recall is that as I was growing up and rap was really becoming popular, and we went through the different phases, the ones with Public Enemy, like when we went through the different things that people were rapping about, maybe about 5 years ago when I was listening to this rap music, maybe it wasn't even 5 years ago, maybe it was about 3 years ago, when I was listening to the people rap, I was just like, they just rap about how they have sex. Like, I was so tired of hearing about the trisexuals, right? And those are the people that try anybody's sex. And when you look at a case like you're gonna have Shannon with the two women, as she's alleging, if there's any truth, that's trisexual, right? Try anybody's sex. That's what I was hearing in rap music. So I really wasn't hearing all of this stuff that they had going on. But what I do know, that in the past couple of years we were seeing a lot of rappers being MDK'd all over the place. So I could see Netflix taking it on from that kind of perspective. And that the fact that these people now they own their masters. Even down to when they took up the guy that was in can't think of his name right now. That's only because I'm not from LA. And you see, just so y'all know, because I have to be real, I was wearing my Tupac. Just letting y'all know today. Um, but it just it's just too much. It's just too much. The more I look at this, the more I just feel like it's just too much. No, the rap today or whatever this was going on is way different. Way different. The arguments and the beefs that these people got themselves into. When you listen to this YSL case, this is Grand Theft Auto on display. That is Grand Theft Auto is driving how they respond to conflict. They handle it like it was on the Grand Theft Auto. But what I love about the people that were involved in this case, right, the ones that we got to know, is that they really had a good relationship with one another. Um, Beyond the fact of being, of trying to finesse their way out of trouble, they had an ongoing street beef with the kids down the road. And there was nobody there that could negotiate or navigate a resolution between the two parties. And in the midst of it, the chicken heads got in the middle, the women, and they went from one side of the bed to the other side of the bed on the other side of town. Um, and it became an all around thing. just an all around get around. Um, which is which ends with a lot of people having to go to trial and stuff. Yeah, this is my Tupac. So that's that. But 2 year last year, yeah, last year I went to Vegas for the first time. And one of the things that I wanted to do when I got to Vegas was to go see where Tupac um last took his last steps. And we went there and we was out there on the highway. I made a video over there like where Tupac is at, and so on and so forth. And I came back on this YouTube and people ridiculed it, right? But I was proud of my generation and what my generation did. Even with the stuff that we did that was not so good, I understood the consequences of everything that was happening around me. I understood why things happened the way they happened and how people ended up the way that they ended up. In this situation, as these people are maturing, right, they'll look at life and see all of these skirmishes as just things that they wish they hadn't gotten themselves into. The two guys that was in the car that they haven't solved their murder, right? My question to Love and Hilton, are y'all going to try to solve that murder? Is it just gonna it is the way this goes down is anybody dies in YSL territory, there's never no justice for it. And moreover, do y'all really need to intercept any like who you doing this for at this point? You're not arresting all of them. Like you're not cleaning up the streets enough where you're taking all of them from both sides and putting them in your one prison and then let them go at it. And who may the best man survive, right? You're not doing that. And I do not agree with the prosecuting people no matter what it is in the music. I mean, the pros wasn't even aware who wrote, the prosecution wasn't even aware who wrote what they alleged was autobiography. To be quite honest, Becky, I believe that that is what I would call a bunch of malarkey. I believe those lyrics represent just what those lyrics represent. Um, they were able to make their statement, and maybe someone did come in, writers did come in and try to round it up at the end. But those people knew exactly what they was writing about and what they was singing about, who their targeted audience was. Like, it's okay to want to get on trial and present a case or present a defense. But then there's the reality of it when you just say, like, I know better. And I think in this case, I'm going to say, I know better. When they're like, oh, the lyrics was written long before the incident even happened. Really? The sensitive men. I saw that too, but somebody else said that it wasn't true or whatever. I think the bottom line is if you live on one side of the fence, I don't know, cause I got my thoughts in this area, but it would just be self-incriminating. So I plead the fifth. Um, I believe that Thug pled guilty. First of all, I believe he wanted out. And I believe they sat around and they, even though you can come out and talk a good game in front of the cameras and say like I wanted this to go to the full wherever it was gonna go, but at the end of the day, let's look at the drawbacks of Thug not being there. People keep going to the other dude. What's the dude's name now? They keep going to Doug Weinstein and saying to him, "Are you going to put on a case, right? Who are you going to call in for your case, and et cetera, et cetera?" He's like, "Oh, I'm thinking about what we should do and how we should do it." I think most of the money left with Thug. The lyrics and all that other stuff. I think all of that left with Thug. Like all of the providing that kind of defense left with Thug. Um, so it's hard for me to believe, based on what I've seen so far, what kind of defense that they could even put out there beyond what the charges are against the defendants. I'm going back to my notes, right? But in terms of all of these, all come from the end. Whatever happened, 57. So, like for Yak Gotti, he's got the conspiracy, right? Which he already pled guilty to some of the overt acts that are in the RICO, which is count one. So, he's already guilty of count one. Count two is the murder. We didn't see it. When I heard Jeffrey never did any jail time on crimes on his record, I understood why he accepted the blind plea. I understood it too. I understood it. I don't feel any kind of way about it. I also remember hearing that he was never offered any plea deals in this whole thing. So when being offered for the first time a plea deal, I'll be getting up out of there too. 57, 58, 59. All of those things have to do with count 57 is the arrest with at Thug's house, right? So 57 is part of a street gang. He's already pled guilty to being part of a street gang. So 57 could be off the table for Yak Gotti. Because they said he already pled guilty to that a long time ago. 58, 59, 60, 61, 62, and 63. These are all the things that they got out of the house that Thug pled guilty to. So it's really the murder that was sitting up there, which is why he couldn't get the kind of break that Thug got. Then the last one, Shannon, he's got he's got 1, 2, and 49. So we know that 2 and 49 are the two malicious murder counts, right? 50 and 51, and and the rest of the stuff is gonna be all the stuff he was arrested with when they got him and arrested him. And I'm gonna say something else now that I'm sitting up here. Let's talk about this. On this fifth count. All right, so count 49 is murder with the four people. And count 50 is the gang affiliation with that murder. Okay. So here's what's important that we really didn't hear. Whose car was Demikion Garlington supposed to be in? They want us to believe that Demikion Garlington, right, which is little D, was in one of the seats in the car that Shannon was driving. Because he was allegedly supposed to be with Shannon, because when they trace his phone records, it's going to be in the same vicinity as Shannon. Why wasn't he in the car with Nichols and Farley? Farley got out of the driver's the back seat driver's car. Why couldn't Demikion Garlington be sitting inside the passenger seat of Nichols' car? I don't give nobody rides at all. Let me tell you, I was at an event this week and I took my car. And when it was time to go home, and people was getting on the trains and they was doing whatever they was doing, calling for Ubers, somebody said to me, you passed by my exit on your way home. And I said, yep, and I'm going to keep passing by that exit on my way home. I'm not taking nobody nowhere. I don't drive people nowhere. No, I never saw it that way. Yeah. Oh, yes, way. When you seen Farley get out the car, right? Farley gets out on the passenger. He's on the driver's side of the car, and I kept saying, "Why is he sitting in the back? If is there somebody in the front? Why is he sitting in the back?" And even if we were to believe that Garlington, which is the little, I'm gonna call him D, because there's little D from Mechanicsville, and then there's one from Cleveland. So little D from Cleveland is the sick one. So little D from Mechanicsville is the person that he's supposed to be riding around with, right? So if Garlington is in the car, he could be also sitting in the front passenger seat of Nichols' car. If you want to insist that he was there because y'all was running and tracking people's coordinates. And the thing about it is no one's saying that they wasn't there. This was me. I was like, yeah, y'all better figure out how y'all gonna get home, but it won't be in my car. She said, "You're right. You're right, Mom." I tell you, I just be sitting here minding my business when I be watching this trial, because that's all I kept saying. I noticed the inside of their cars be so nasty. Now let me tell y'all something. Mm, mm, can't can't stomach that, can't stomach that, can't stomach that, can't stomach that. Nobody's getting in the car after I saw the trial. Just my child. Um, mm, mm, mm. Nah. First of all, not for nothing. Who was it? It was one of those little car rides that they had, that one of them got shot because somebody's gun went off in the back and shot the person in the front. Yeah, I'm not playing with these people. But I mean, I don't have people that are involved in activities. No. Oh, those infinity. Actually, my friend has an infinity. My friend has an infinity. Oh, are you looking to see what trash day today is? Let me look on the app. Hold up. I think it's bottles. Please hold a minute, y'all. I have to see what kind of trash day. Oh, you sleeping? Tell somebody to put out the garbage. They're gonna be like, pretend I don't. Yes, it's co-mingle day. You want to get a plastic bag out the trunk? Do we have a plastic bag for? No, no, that's not what I'm asking you, honey. Do we have a plastic bag in that area? Well, can you check for me to see if we have a plastic bag? Cause I have to go to the car to get one. Well, could you put the other garbage bag out? All right, just put the trash out, and then I'll deal with the recycles. All right, so that's about that. So sorry about that. Yeah, I never wanted an Infinity. I did go look at Infinity one time. They got a lot of features in the front of their car. I'll just stay with my Nissans. But I will tell y'all that I am gonna go get me a pew pew because I need a pew pew. And after listening to that girl, she was like, I don't even know. I just go to the range and think I was like, I want to be one of those babies. I want to be going to the range and doing all of that. I need to be doing all of that. I just think when she said she was shooting with her eyes closed, I was like, what is wrong with this picture? And I remember somebody else saying, they ain't got no aim. She was her eyes was closed. She wasn't aiming. She was just shooting. They were calling Thug Rapper Boy. Well, yeah. Let me tell you something. Every relationship is spoiled at this moment. There are very few relationships that could mend over this. You know, you probably won't even want to pass some people in passing. You know why I don't rob people from the hood, and because the problem with that is that when they get in your vehicle, anything that they got on them that you're not aware of, you going down with them. And I ain't got time to be going down with people. I'll be getting in trouble all by myself. I don't need to be going down with you. He was in those same clothes. Man, 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 oh man, Lauren. Man, I know what you're saying, Bingo, about the people being in the car. And that's like what you tell your children as your children are starting to get their driver's license and stuff. Like, listen, you can't be carrying your friends around because, as the owner of the vehicle, right, everything that's going down in that vehicle is going to go down with you. So you got to make sure that people don't have nothing on them. It's too much drama. Um, that wearing them clothes, that pink ass hoodie, and I said it. I said it because that's how I said. I seen it. I was like, dude, dude, dude. But they kind of made up for it when they said he was in the studio. So I was like, he's in the studio really putting out some work. Do you think he was in the studio putting out some work, or you think he was in the studio hiding out? I just saying. But I still go back to the car that rolled up fast. I just saying. I know, you know what, to be honest, it don't be the men's cars that be nasty. It be the girls' cars. It be the females. You can't you listen. They start moving stuff off seats and stuff like that, and you be like, "What's wrong with like? What's going on?" I'm mad at my car. I got the shovel. Been in the car all season long. I got the shovel in the back seat. It be killing me just seeing the shovel back there. So I just imagine, but I get into some chicks' cars and they just be like, especially if you like come from work or whatever, they just be like, "Excuse me, let me move this." I'm like, "What are you doing?" Like, no, that's all right. See, I don't want to sit there and thinking I'm getting crunchies in your car seat and stuff. I'm saying, yeah. Um, hold on a second, y'all. I'm gonna have to mute. What am I streaming from? Oh, I don't know how to mute this. How do I mute this? I mute this. I'm sorry. Y'all not gonna believe me. I can't even tell y'all what that's about, but that's a mess. I need to mind my business. Wait a minute, let me just go over here. I missed someone. Okay, heck no. I have OCD in my. Well, I'm not gonna say I have OCD, but I have OCD when it comes down to sitting in some people's cars. That I do know. You understand that I can't sit there and see crumbs on the floor, mats and things. It's just you. I remember I was gonna go date. Well, I met this guy for a date, right? And I am bad with going to the car wash. But let me explain, okay? my side view mirror got hit. So every time I go through the car wash, that thing comes off, and it's just a whole nightmare because I gotta either bag it up before I go through the car wash or whatever, because the casing comes off with the things. So I have to go to the ones that do the hand car wash. Talking about the car wash, babe. So I don't have that many hand car washes here in Jersey like we had in New York. And normally I would just go to the peoples and let them wash my car. Hand car wash, babe. Right? So, ugh. So I met this guy, and he had the audacity to do like a swipe on the outside of my car. And I was so mad with him. He was like, why don't women ever clean their car? Like, I can write dust, dirt, bucket. I was like, all right, so that's the outside. I was just so mad. But then he looked on the inside. He said, so how come the inside? I was like, because I vacuum clean it. I do all the little things on the inside. I just don't got time to be going and trying to do that. And it don't come out right if you don't know how to wash a car. Because I've tried. I'm not a car washer person, so that's not me. But yeah, I mean, yeah, that's me. That's me. Well, I don't do it every day, but that's me. That's definitely me. I got a little hand vacuum in there. I come up here and I charge it or whatever. Best part of my car is when the child sits in the back. No, I was on the phone. I had to take a phone call for one of my neighbors. In my house, like my house, and my car, my house, and my car reflect who I am. So I'm like, so my home and my car are clean always. We had to bathe and scrub everything. You couldn't touch the bed and be dirty. That was a whooping. Yeah, but I don't even understand. You know what though? I was watching this other live stream, and they was talking about um the pink outfit for 3 days, the pink hoodie for 3 days. The pink hoodie for 3 days. I was making facial expressions when I was on the phone. If I tell y'all what that's about, you're not gonna believe me. Um, Now what are you doing with shoes in the back seat and a hat? No, I have a whole shovel back there because I'm not getting stuck in thing. I'm not getting stuck. But you know, in the back of my car, I have the Rogue. So in the back of my car, it has this hidden thing, you know, where the back stuff is. But you know, cars are so complicated now because in my back part, right, where the thing comes off in the back, I got those the bags for the supermarket. So now I've had to get like something to hold the bags that are for the bags for the supermarket. Then I had to get a second one because I had so many bags, you know, for the supermarket because I forget to bring the bags back downstairs or whatever. So now I got the bags from the supermarket, and I use the it's like some kind of crate or something that you carry the stuff out of. And that's it. When I used to go to my grandma's house back in the day. Yeah, it's like, I mean, it's just a part of your. It's just a part of your thing. We had to go sit on the couch. Oh, but you can't be wearing your jeans. You know why? Because the blue dot. Yeah, the blue dot. My children must have been miserable kids because I had a beige, a light beige sofa when they was kids. That, and when they was babies, I had it upholstered with the plastic on it, Puerto Rican style. Yo soy puertorriqueña. And then I took it off, and I used to be anal with it about it. You know how they got that new cloud couch? I wanted one. I refused to get one. Yeah, I don't know. I don't pump gas. I live in Jersey. They pump the gas for me. I be coming through the thing to make sure I get gas in Jersey. There's no way I'm not getting gas in Jersey because they it's fully pumped. I'm not pumping nothing. I be so deficient remembering how to pump. It ain't even funny. And yes, I be acting super bougie about that pumping gas thing too. I got little quirks with me. I wonder why that still keeps letting out like that. Anyway, I'm gonna tell y'all a funny story and then I'm gonna go because I'm sure the person's gonna call me by that time. The other day, somebody contacted me and said, "Hey Mo, hold up, where was I at?" Someone contacted me. This is way off. Somebody contacted me and said, "I'm not feeling well." La da 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 da. Blah 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 blah. Right. But hey Mo, um, at the end of the not feeling well, could you open my door for me? Do some things, right? One of my neighbors, right? So I went and went over to open the door. They said their key was not working in the door, and that they was feeling a certain kind of way. People were chasing them, was like nervous or whatever. So I was like, well, why would somebody be chasing you? So secretly, they whispered in my ear and said, I hit 3 cars. So I was like, oh, okay, that's interesting. So I left, I left it alone. I then saw a couple of hours later them speaking to the police in the camera, right? So I saw from the camera that the person was speaking to the police. But I went when they told me they hit 3 cars, right? I went and looked at their car and I didn't see any physical damage on the car. There was some damage on the side of their car, but I didn't see no physical damage, right? Like not nothing that would say like 3 cars, right? But then I saw them out of the camera was talking to the police, right? So I didn't pay it no attention. And then the next day passed and their mail was still outside on their property. You know, like stuff got delivered and it was still sitting in the open where everybody could see it. So that was the following day. And then today, the mail was still sitting there. More deliveries came. So I took the deliveries in, right? Because I figured that the person was not home. All right. Their car was not there anymore and they was not home. So later on, I was trying to do my live stream earlier and set this up. I get this ringing of my doorbell, and I go downstairs, and it's the person, and they're like out of it, like something, something, something. So I was like, all right, I'm gonna let this go, and this and that. But now they made a big enough scene outside that some other neighbors came over and was like, I think we need to call 911 because the person is seeming like they're delusional or whatever. So I'm sitting there like, okay, okay. So, long story shorter, the police officer arrives, right? First police officer comes over. So they're explaining how the person is seeming a little delusional, not in it, or whatever. So I'm like, who called 911 which time? Because the neighbor called 911 on this day. This is like 2 days later. The neighbor called 911 to say that they felt like this neighbor, something's wrong with her, that she might be a little bit, what's the word? They like senile, but like some other word for being out of it, right? And I'm sitting here because, I'm Jenny from the block. And I'm like, girlfriend done hit three people's cars. I saw her speaking to the police and her car is gone now. So you know what I'm thinking? I'm thinking this is an act. No, I did. I didn't call when she told me she hit three cars. So am I gonna call now that she's standing here? Like, I don't know, right? So now I'm sitting here, kind of sitting down there on the steps, and I'm like, well, um maybe she did hurt herself when she hit. Da da dum 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 dum. That's exactly what I was thinking. So, anywho, they called. The police arrived. So the first police officer comes. So he's like, "So why am I taking the report?" And just that. So she's like, "Somebody's been in my house and wrecked my house all up." Right now, me knowing that I was the last person over there, from what I could see from the camera, because I wasn't worried about her when she didn't pick up her stuff. Right, because I saw her go in, but I never seen her come out, right? There was no like being like she came out, right? And I hate the way this camera is because every time she moves, it comes on my thing. So I didn't see her leave, but I saw her go in. I never seen her come out. But it was like a hit and run because her car was now parked in front of the house when I went to go see it after she done told me the story. All right, so make a long story short, second police officer arrives, right? And you know these cops are funny. So he's like, yeah, he said, so how you doing, Miss So and So? Knows the lady's name, right? He's like, how you doing, Miss So and So? He said, "Remember me? I told your car the other day because you hit three cars on the corner there." So I was like, "On the corner over there?" So then the other lady's like, "That's why I don't park my car over there no more." So now I'm looking at them like they all got 10 heads. And I'm like, "See, when you call the police." So she's up here acting delusional. So they called for the ambulance. So then the other lady's like, "Well, they called for the ambulance. That's a good thing because he's trying to make it seem like it was I was like, she hit the people's car and ran. But this is what I told her when she whispered it in my ear. I said, that's a hit and run. You're gonna When I spoke to her, I was like, that's a hit and run. You're gonna have to call the police, right? So when I seen her out the camera talking to the police, I didn't think nothing of it. I thought maybe she took my word on it and she called the police. But when I didn't see her car anymore, I had no idea that they towed her car. So now she want to pretend like she was missing for a couple of days and somebody came in and destroyed her home. So the police came in there. So they was like, "You want to go and look?" And I was like, "No, I don't want to go and look." But they couldn't find her keys. So they said they was leaving her house open. And if we would keep a watch on it, I was like, "Yo, where they do stuff like this at?" So anyway, that was her son calling me to tell me that he's gonna come and lock up the house, but he wanted me to know. And I'm like, listen, too many people got cameras around for your stuff not to get seen, but you gonna go park your car in front of the house and then play whatever. So I don't know. I told the guy when he come, then I'll stop my live stream. He's like, "You're live?" I was like, "Yeah, I'm live." So I'll stop my live stream to come and witness, but I'm gonna have to have my camera out because I'm not getting involved with anything. Please ask me. No, I'm not gonna play stupid. I'm just not gonna play games with people either. I don't want to have no parts of none of this stuff. I'm an accessory after the fact. It's just crazy. But I listened to them people. Them people was like, I was, and I'm saying to her, how did you get them involved? Like, no, yeah, it wasn't even a great job. It was the worst acting I ever saw. And let me tell you something, right? I got this other neighbor, and she's looking at me, and she's saying, "Oh, this is so sorry." You know, it's a Spanish woman. She's like, "Oh, this is so bad." I was like, "Girl, don't fall for it." She's like looking at me. I was like, now you're gonna play like you silly or whatever. And I'm gonna tell you right now, we came from the supermarket yesterday. I'm just terrible with this story. We came from the supermarket. Somebody weed was all outside in the container. I just was like, you know where I went wrong? I bought in the stuff that didn't get delivered. And the only reason why I bought the stuff in that the deliveries, right, was because if we leave them out there, later on, somebody else will be robbing us the same way. All right, look, they go homie at the door. So I'm going to go. But I'll see you good people on the next day. I should have kept the live open. Hello? Oh, you look like your mama. All right, I'm coming downstairs. you can't you can't you you can't you can't deny her. You certainly do look like y'all related. Okay, hold on. Yeah, your identity. Right. Something wrong with me. I see y'all on the back end. This is Mo.